Legal systems across the world differ in their foundations, structures, and methods of interpretation, reflecting the diverse historical, cultural, and philosophical contexts from which they emerged. The most prominent systems include civil law, common law, religious law, customary law, and mixed systems. Each offers a distinct approach to how laws are created, applied, and understood, shaping the legal landscape of nations and influencing global legal interactions. Civil law systems, which originated from Roman law and were later codified through instruments like the Napoleonic Code, rely heavily on written statutes and comprehensive legal codes. In these systems, legislation is the primary source of law, and judges play a relatively restrained role, focusing on applying the law rather than interpreting it expansively. This structure promotes clarity and consistency, making civil law systems particularly prevalent in continental Europe, Latin America, and parts of Asia and Africa. Their codified nature ensures that laws are accessible and predictable, though they may lack the flexibility to adapt quickly to societal changes. In contrast, common law systems, which developed in England and spread to countries such as the United States, Canada, Australia, and India, are based on judicial precedent. Here, past court decisions serve as guiding principles for future cases, and judges have a more active role in shaping the law through interpretation and reasoning. This system is inherently dynamic, allowing legal principles to evolve in response to new circumstances. While this adaptability is a strength, it also means that the body of law can become complex and less predictable, requiring legal practitioners to navigate a vast array of case law. Religious law systems derive their authority from sacred texts and religious traditions. Islamic law, or Sharia, is the most widely practiced religious legal system, governing both personal and public conduct based on the Quran and Hadith. In countries like Saudi Arabia and Iran, religious law may serve as the primary legal framework, intertwining moral and legal obligations. These systems reflect deep spiritual values and community norms, but their application can vary significantly depending on interpretation and may sometimes conflict with secular legal principles or international human rights standards. Customary law systems are rooted in traditional practices and societal norms, often transmitted orally across generations. They are especially prevalent in indigenous communities and rural societies, notably in parts of Africa and the Pacific. Customary law emphasizes consensus, restorative justice, and communal values. Although it may lack formal codification, it plays a vital role in maintaining social cohesion and reflecting local customs. However, its informal nature can pose challenges in ensuring consistency and legal protection. Many countries operate under mixed or hybrid legal systems, combining elements from two or more traditions. For example, South Africa integrates civil, common, and customary law, while Israel blends civil and religious law. These systems aim to harmonize diverse legal influences, though they may face difficulties in achieving coherence and uniformity. Understanding these systems is crucial for legal professionals, particularly in international contexts, as it facilitates effective cross-border collaboration, dispute resolution, and policy development. Each system offers unique insights into justice, governance, and societal values, underscoring the importance of legal pluralism in a globalized world.